Here are three important things you need to know about reasonable accommodations to your disability at workplace in California. Number one, the accommodation that your employer provides to you doesn't have to be a perfect accommodation or the accommodation that you pick out of all the possible accommodations out there. It only has to be a reasonable accommodation. Example, let's say that you have a disability due to a back injury. Let's say you have some type of back pain and it has been determined by a doctor that you could use an ergonomic chair as an accommodation at workplace. And you find such a chair online for $2,000. Your employer comes back and says, it's too expensive. We found another chair that should work for you for $600. If that chair in fact satisfies what you need for your condition, then that will be a reasonable accommodation, even if it's not the best or the perfect accommodation out there. Number two, you may be entitled to an accommodation even if you exhausted your FMLA or CFRA protected leave. This is one of the most common mistakes and most common misunderstandings that many employers have about FMLA and CFRA. They believe that once you, the employee, exhaust your FMLA leave, that's it. You're not entitled to any more leave under any circumstances. This is not correct. Quite often, employees are entitled to additional leave as an accommodation to their disability after they exhaust their FMLA leave. And in any event, you may also be entitled to other accommodations after you return from your leave. So you potentially could be out on leave for 3-4 months or extended leave for 6 months. And then when you come back, you may still be entitled to an accommodation such as, again, ergonomic chair, modified duties, modified schedule, some other assistive equipment, lifting restrictions, pulling restrictions. In other words, it's not either or, either leave or accommodations. Accommodations often follow restrictions to your job duties, often follow as they should your leave, because leave is no work at all. And then when you come back, often what disabled workers need is limited duties, lighter duty before they can go back to work in full capacity. And number three, an employer doesn't have a legal obligation to provide indefinite leave of absence. Now, what you should watch out for is when you receive a note from your doctor that approves your medical leave, make sure that that note doesn't say, oh, this employee may never come back to work, or it's not clear how much time they will need to be off, or they're on indefinite leave of absence. The moment the employer gets this type of information, they can lawfully terminate you. Now, you don't have to provide a precise date of your return to work, even if you're able to provide an estimated date of return. For example, your medical note might say that this employee is expected to return to work by this date or in 8 weeks. When the time comes, you can still extend your leave. There's no bright line rule as to how long your leave can be, because this really depends on the circumstances, your company size, your employer size, and the resources, the nature of your job title and your duties, how many other employees can perform the same duties while you're out. But as long as you don't say that it's not clear when you're coming back, if ever, as long as you provide some, even if it's not an exact date of return, it will be much better for you in terms of meeting your obligations under disability laws